All right. Well, good morning, everyone. Thank you for joining us. I see right now we have 31 participants. We have about 90 signed up, but I am Ann Anderson, and I am your moderator for this roundtable for the dispute resolution section. We have panel members who will be talking, and they will just introduce themselves. This is a really great, terrific, experienced group who has some interesting topics that we can be addressing. And this quarter's topic is dispelling mediator myths. And we will be talking about some of those myths, but I think the first one we want to talk about is one that made the rounds on the listserv that was raised by Renee. And so I will start us off in just a minute. I do want to say, if you want to speak and you're not on the panel, if you'll just either raise your hand or put something in the chat and try to limit your discussion so we can keep the discussion of the panelists focused. And if you'll just mute yourselves if you're not speaking, that would be great. So thank you so much. So the first topic that Renee raised really is about payment of mediator fees. And there are a lot of myths about payment of mediator fees. And I think different people have different perspectives about what the rules say, about what they should do, the attorneys, the parties. And so, Jackie, I'm just going to ask you to lead us off. If you'll address what you have seen with non-payment of mediator fees and perhaps some of the solutions, and then also Tara, if you can help weigh in, I think that would be great. So Jackie, you and I've had this discussion quite a bit because just all kinds of things happen when people don't pay the mediator fees. But Jackie, I'll turn it over to you.
Thanks. And it is just a really frustrating process. And I think kind of, the thing that makes it particularly difficult for us is because we don't have that relationship with the party, the way an attorney has a relationship with their client, a creditor has a relationship with the debtor, that sort of thing. For the most part, we're usually, removed because there's an attorney there. Frankly, the pro se parties I mediate for pay me promptly. I'm having more trouble when the attorneys are involved. Just real quickly, I want to, go over the rule on that because I'll hear people say various things that they're doing and actually, the rule doesn't allow it. So right now I'm talking about Superior Court mediations. The Industrial Commission has a different process. I don't know about family, financial, and so folks will need to weigh in. And also, I don't know what the right answer is. And so I'm curious about all the comments. And I just think what we need is a more streamlined process. And I think, if we as a group and with the commission could try to get something that's more effective for the mediators, because ultimately what happens for me is, I keep trying and I keep trying. I don't get paid. If I have to go to court, I'm going to lose a day of work. And ultimately that, they don't pay, as I fear, to the other side. So Rule 7 of the Mediator Settlement Conference rules addresses compensation of the mediator and sanctions. Obviously, by agreement, if you're selected, you can put, what you want in the agreement about payment or payment by the parties. That's Rule 7F says, unless otherwise agreed, payment shall be due upon completion of the mediated settlement conference. Well, we're not getting paid at the conference or within the days after. And it also says the mediator's fee shall be paid in equal shares by the parties. And I know, some folks have talked about, well, I tell the attorneys they're responsible for the fee. I will say years ago, I heard one attorney talking about a mediator that said the attorney needed to be responsible. And he just said, I'm never using that mediator again. That did stick with me. Also, I just try to follow the rule, even in the mediations where I'm selected. Let me just kind of go over a little bit more on the rules and then open this up. So you don't get paid. I'll I'll send an invoice on the day of, and then in about 30 days, I'll send a reminder invoice, and then I send another one. And so about 3 invoices in is when I start saying, at this point, I'm going to have to file a motion, for payment, and then I'll send them a copy of the form. And it's AOC CV 815, motion in order for show cause hearing. And then AOC CV 816, order of contempt for non-payment of mediator's fees. And so this form, though, for service has you serving the party, and it says either personally handing it to them or having the deputy serve it. And if you look to civil contempt, that's 5A-23A1, it says that you do need an affidavit or you need it notarized. So this motion, the AOC motion, does need you to require you to notarize it. But when it talks about service, it has you, having it served by the deputy. And so one problem I have is that under 1A1 Rule 5, the Civil Rules of Procedure for Service, once a complaint's been filed, you can serve the parties by email to their attorneys if they have an attorney. And so I don't know, and y'all can answer this. I'm not an expert on this, basically because I end up just letting it go. I don't know why we can't serve the parties by emailing the attorney, since Rule 5 allows that for service. So that's one thing. And so, it's just a real frustrating process. At the Industrial Commission, all you have to do is email the mediation coordinator, tell them you haven't been paid, the way you've tried to get paid, the invoices and that sort of thing, copy the attorney. Let me tell you, he sends something out that says, if you don't pay within a certain number of days, you're going to be in contempt. I'll tell you, in bankruptcy court, they don't mess around. Back when Judge Leonard was a bankruptcy judge, he sent an order and said, if you don't pay in 14 days, you're going to jail. I kept a copy of that one. That one I got paid like within days or maybe the same day on that one. So I think, that's a problem I'm running into. There are just a lot of questions. And I just think it would be helpful if we could get a statute in place or a rule in place to help mediators get paid. And then one more thing I wanted to comment on and then just open it up. Another thing I'm getting a lot of, and I've seen comments on this on the section listserv, the expedited payments, the V cards, I'm getting those from insurance companies. And, they're going to be processing fees. So I basically tell them I can't accept it. And then they send me a check. And so the ultimate effect is that slows it down another 30 days. And so I'm just getting more and more of those. And again, there's a processing fee. So that's becoming frustrating. So, Ann, I wanted to kind of go over that, and y'all can tell I'm very frustrated.
Yes. And so, I remember back in the beginning, people would bring cash to the mediation or write you a check. And then that's kind of fallen by the wayside. Whereas now it's almost as if the parties and the attorneys believe they're in charge of the payment, and you might have to go through a portal. I've had that happen, or you have to bug them, or they set certain conditions. I actually had a defendant one time take a 3% discount because they paid me within 30 days. So there are all sorts of things, but I don't think people know the rule where it says the payment is due at the completion of the mediation. So that's one myth we need to dispel, that it's not that somebody can wait for months to pay you. But folks, if anybody on the panel wants to talk about solutions or problems that they've had, and how you address them. I think a lot of people think we should just be doing this for the joy of getting a resolution. So Any comments from the panel? Tara, I do want you to weigh in kind of about what the commission has seen, but Trish, if you had, and Ray, okay, Ray, you raised your hand.
Yeah, I can't answer Jackie's question because it's too early in the morning. That's way too difficult, Jackie. But this is something I'd be interested in what the panel thinks, or anybody on the call. It's kind of the interplay between the non-payment rule, but obviously our duty of confidentiality. There's an exception, of course, if you have a communication from a participant about non-payment, you have an exception, as I read that, to confidentiality. And I know we're all wearing our pajamas, but here's a hypothetical that a lawyer in a big firm doesn't pay you or arrange for your client to pay the fee. And then her partner calls you up, her law partner calls you up 30 days later and wants you to mediate. You say to her partner, you know, I'm not going to mediate for you all if a big firm doesn't stand behind their fees because your partner so-and-so didn't pay my fee. Are you permitted to disclose, at least in the context of a partner, that there's been a non-payment? Or are you precluded from that under your duty of confidentiality? I know Frank Laney knows the answer to this, but I'm wondering if
I think I do.
Okay, Frank, go with it. Go for
Well,
it.
my answer would be the non-payment should be on the affidavit, normally called report of mediator, that you have already filed in public with the court. That's not confidential.
Okay.
That's my interpretation.
And
Now, Kara may tell me I'm wrong, but the fact that somebody has not paid your fee is not confidential because you are required to, within 10 days of the end of the mediation, file a public affidavit with the court called a report of the mediator, which denotes who has and who has not paid your fee.
But what do you do, Frank, if people don't pay for like a month or 5 weeks and you have to get your report of mediator in within 7 or 10 days?
Then you put on the back, well, on the 10th day. I mean, I'll admit that I have violated this rule. I've gone longer, trying to be nice to the parties, trying to be nice to them. But
Tara's covering her ears.
I have a window of time in which I'm required to file this report. If you do not pay me within that period of time, it will go in the public record that you are a skinflint, that you have not paid my fee. And I am, you know, I did not write the rules. Actually, I sort of helped. I did not write the rules. These are the rules of the commission. I am following the rules. If you are supposed to follow the rules too, I apologize, but I'm going to have to denote in the public record that you owe me $1,000 or $500 or whatever the number is, and then I file it. I mean, you know, I know they don't like it, but you know, generally it's not the lawyer that gives me a hard time about it. Generally, the client is the one who doesn't like, who I'll get some pushback from. The client doesn't like being called, you know, a cheat, whatever you want to call it, whatever word you want to put to it.
But frankly, I have no qualms about putting it in the report, and I never thought about just going, hey, you know, I'm getting ready to put your name down on a public record that you haven't paid me. I mean, so many of them, you know, don't pay on time. I just don't even think about it. When I file my report, they still owe it and it goes on there. And I kind of get the sense nobody cares.
Yeah.
Well, and most people don't. Yeah, you know, I mean, how many million pieces of paper in the clerk's office? There's one that has my name on it that says I'm a cheat. You know, I don't care. You're right. Most people don't, but there are some people that seem to be a bit incentivized by that. And to answer your question, something that I ran across recently, just sort of, it happened, won't say it's epiphany, just sort of happened. I called Tara and Tara said, sure, sounds fine to me, which is, if there is a transaction going on as a part of the settlement, you can agree with the parties to have your fee taken out of that transaction. So that was mine. Somebody was buying somebody else out, and you know, it was $150,000 going to be paid, you know, within 30, 60 days. During, you know, after the transaction was set up, one side paid, the people who were going to buy the thing for $150,000 paid, but the other side was not. Admittedly, the other side probably was a bit on the poor side. I don't know. probably could have paid my fee if they really wanted to. But so I talked with both attorneys and said, look, I haven't been paid. Are y'all both okay? And please talk to your clients and see if they're okay with simply my fee being withheld from the transaction. And the client who wasn't paying his attorney said, yeah, as a matter of fact, I'm owed a bunch of money too by this client, attorney's fees. And what I'm going to do is structure the deal such that the $150,000 goes through my trust account. And so, yeah, whatever you are owed by that day, I will pay you out of the trust account. And also, I will pay myself out of the trust account. And then the client will get $149,000 or whatever the number is. So I never thought about that before. Maybe it would work in some situations that y'all have to take your fee out.
I'll have quite a few where they agree, one side agrees to pay my fee. I've not talked to them in that regard about getting it paid. But, one time I had a defendant to agree to pay the entire fee and they weren't paying me. So, I was getting shorted not only their half, but the other half. I don't know. I haven't thought about just saying, y'all make sure I get, I don't know. That's an interesting concept.
Well, I'll pass along to the group just quickly. I had a law partner that told a non-paying client once, I like to pick my own hobbies. And that's a nice saying to use. It's a little bit rough to use. I like to pick my own hobbies when you're not paying me. And he got paid.
Well, so Ken, I see you unmuted yourself. So you may be like me in federal court mediations. I never get paid within 10 days.
Yeah. Yeah, that's exactly right. I mean, when I do the state court, there's that form, obviously, where you have to designate down at the bottom who's owes what, and whether they've paid and all. And in federal court, you don't have to report on that kind of payment status. And every now and then you get somebody that shows up and wants to write you a check right then, and I bless them and I thank them. But that doesn't happen too much. For the state court actions, I've just never had a problem with this approach. I mean, certainly I've had a problem with being paid timely, but I don't expect the payment by the time I file it. And I put on that form, parties to be billed. That's all I put. I put how much is owed, parties to be billed. And then if they haven't paid within, I usually allow 45 days. And if I haven't been paid, I follow up with them. Generally, that works. Generally. But certainly not always.
I've actually used the process and it was when an employer did not pay me and went to court and was standing in the middle of the courtroom with my motion for contempt pending, and the woman pulled out cash and paid me on the in the courthouse. But I mean, it took a day. I was actually in the eastern part of the state, and I was really mad because I knew that they had the money and just wouldn't pay. But Tara,
I've never filed anything. Let me just say that I tend to try to shame them after about the third follow-up, and that usually works. And I have got a little phrase that I put in that I'll send it to the attorneys and say, look, I haven't been paid by your client or you, and I'll be glad to send you my petition to the court or whatever I want to call it, if that would help. And generally that little nudge has worked well. And I don't have a formal agreement for mediation, but I do have a fairly involved email that becomes my agreement. And in that, I have a line that I started using a year or two ago, which is, the obligation to pay, if the client doesn't, it's upon the law firm. And by proceeding with the mediation, all parties and their counsel agree with this arrangement. So it at least gives me a little bite to it. I haven't had to use it, but
I
it
think John
gives me
Harkavy mentioned he
yeah,
did that.
I put that
so.
right up front in my initial letter.
Well, so
Have you gotten any pushback on that, Ken?
Never.
Because,
Never. Not one.
and I do the same thing you do. I have these follow-ups. I say, this is what I'm getting ready to file, and all that. And normally that does get payment. But right now I've got two that, just they kept responding, then they've gone radio silent.
Yeah.
It looks like Roy's got a comment.
yeah, Roy, you want to just
Sure.
say a few words?
In some ways, it's just like our work as mediators, right? We want people to eventually talk to each other. And so I just don't rely on email. I certainly, or letters. At some point, I call and try to talk directly with the attorney who was involved. And, typically, I didn't know that my client hadn't paid. If it was an insurance representative or insurance claim, or sometimes they'll pay out of their, they'll pay themselves and then get it from their client. So I just encourage us to be, we don't have to demur, we don't have to be shy about asking to be paid. And so I think it's fine to call people and directly have that conversation with them. That's all I'm just highlighting.
May I
Thank
ask a
you, Ron.
question about the family financial mediators? I don't do that, and I'm not sure any of you all do. Tara might know this, but in the Charlotte area where I am, they tell me that they expect and demand payment at the end of the mediation, not just what the rule says, but they expect it to be paid then. And that may be because of the volatile, highly emotional nature of domestic cases. I'm not sure, but I'm curious if any of you know, is that a kind of a statewide practice to all family domestic mediators want to be paid, expect to be paid at the end of the mediation? I don't think that would work for us to demand that, but I'm just curious, is that something you all have heard?
So Tara, I'll defer to Tara on that because I know she's done family law as an attorney and then in the DRC. So Tara, if you can talk about that.
Yeah, it was common practice back in the day when I was practicing and mediating in Wake County to pay the mediator immediately. And it was tricky when you had a client that was not paying your attorney fees and you knew you were walking into mediation and your trust fund did not have enough money to cover it. I would always tell my clients that they had to bring a checkbook with them to mediation in order to proceed with the mediation because the funds were due immediately. The problems that we have collecting the fees are, let me put it this way, we have a system in place. It's not perfect. We do our best to try to educate attorneys, which I think is the biggest downfall right now, that the fees are due immediately upon the conclusion of the mediation. For family financial, it's easy because typically at the end of that mediation, everybody whips out their checkbooks or credit cards and they pay and it's done. Superior Court, I understand, is a little bit different. You're dealing with big law firms, insurance companies, you're dealing with parties that don't necessarily want to bring the cash with them or their checkbook to pay the fee. And so billing is typically offered by the mediator. Technically, under the rules, it is required that the fee is paid at the conclusion of the mediation. I know that the chain that has gone around that Renee started, which has a lot of great information on it. I think Frank Goldsmith made a very good comment of, nobody pays at the end of the mediation. It's just not common practice. And it's not super clear in the rules. And the commission has considered it in the past and they've declined to do an advisory opinion or modify the rules. This is something we can certainly take a look at again to see if there is a way to clarify in the rules that payment is expected at the conclusion of the mediation, and that the fee shall be paid within 10 days. But ultimately, at the end of the day, putting it in writing is fabulous, but it doesn't necessarily mean that in reality it's going to work, right? So we have these, we have the ability to create change within our rules and our advisory opinions. But I don't know that adding a line in the rules is going to make that much of a difference because the only people that read our rules are certified mediators, not the attorneys who are working with the clients, taking them through mediation. So the staff here, we are trying to educate attorneys as much as we can. The problem is we don't have significant draw when we do a CLE. People are like, yeah, why would I go listen to, someone talk about mediation? So we are working with the NCBA on doing an expert series for attorneys. And then I'm also working with Mecklenburg County Bar to set up the same thing. So we can hopefully get the word out to attorneys that, hey, look, the payment is due immediately, and educate the attorneys on what is required of them under Rule 4 from the Supreme Court, which most attorneys don't even realize that they have obligations under our rules.
So Tara, talk about getting the part of the fee in advance or getting a deposit. If you would just mention that, because there's that rule, that advisory opinion you noted for me, 19.
Yeah. So this is great. And it's funny because I don't know if everybody has access to the listserv that was going around, which has some great information on it. But Keith and Sony provided, he laid out a bunch of different options. And I immediately tagged in and I'm like, whoa, you've got to mention AO19, because even though, his advice is stellar, it's not complete. So when it comes to a retainer, if you are designated by the parties, you absolutely can put in your fee agreement, service agreement, contract for services, whatever you want to call it, that the parties are required to pay you a retainer to conduct this mediation. That is perfectly fine. However, you cannot delay the mediation process if you have not received payment of those retainer funds, right? So you are still obligated by the court if you are designated and it is court ordered to conduct the mediation prior to the deadline. Rule 6 still applies. It is your responsibility whether you have those fees or not. But you can certainly ask for those fees and require it. And if you are working with the same law firms or the same companies over and over again, create a change. Hey, here's my engagement letter. I'm letting you know that my mediation practice, we are implementing new procedures moving forward. As of this date, we're going to expect a retainer to be paid in this amount for each mediation. This is what we're looking to collect. Unfortunately, you all are in a customer service industry. I understand that you don't want to anger the people who hire you to conduct these mediations. But until we change best practices and what mediators are doing in your counties, nothing's going to move, because as you all have commented on, they're just going to hire a different mediator who's going to let them pay them 6 months later. So it needs to be kind of a force from within, I think, in order to make change, to effectuate change. We kind of have to band together and say, this is how it's going to be. This is what we're going to allow. This is what we're going to put up with. And if you can't pay me, if you have money due on my account, I'm not mediating for your firm until those monies are paid and satisfied. And here's how I want to move forward. It sounds great, right? In reality, it's going to be very difficult to implement.
So Renee, say that you've raised a couple of issues. So Renee, if you just want to chime in, because I think your second point is one that we have to think about.
Yeah, so thank you. And forgive me if the first point is something we've already talked about. Also, forgive me for being off camera. We're in the midst of renovations and found out that the moving truck that was supposed to be here tomorrow is here today. So, but this topic is so important to me. I did want to weigh in. A couple of things. The one that I hope is not repetition is, Ann, you mentioned that some firms were requiring the submission through a portal. And I've had a couple of iterations of that. So initial delay was one in which they didn't even tell me about the portal until the bill was already 30 days late. They sort of turned it over to this kind of central national person who was incredibly unhelpful and quite frankly rude. So then there was all kinds of technical problems with the portal, and that mediation was in January and we're still not paid. So I need to do the draft motion, which I've done in other cases. That's been effective, but then I got this situation that I raised in the second point, and that is send it. Got this really nasty call back saying, you're creating a situation that puts me in, conflict with my client with this contempt motion. And, a couple of things about that. Our letter in all cases says, that even if it's pre-suit, that you're going to be governed by the MSC rules. We cite the rule, we cite when it's due, often to no avail, that it's just absolutely ignored, like so many of you have commented on. And so because of that, I think I talked through it with him, and we got paid, and I'm like, what is the alternative? You want me just to eat this? I mean, what's the rationale for that? And the letter also says that the lawyer is responsible, that we hold the lawyer responsible for payment. And so I don't know why I couldn't put the lawyer on the contempt motion instead of just the client. So
I'm going to jump in on that one because that's great, Renee. It's great to hear from you. The rules require that the parties pay the mediator, not the attorneys. It is common practice for mediators to bill the attorney's office and to talk only to the attorneys, because as attorneys, we're trained never to talk to the clients, right? Mediation is a different beast, especially court-ordered mediation. Your client as a mediator for court-order programs are the actual named parties in the action, not the attorneys. So you have the ability to talk to the parties directly. Common courtesy doesn't necessarily indicate that's always the best solution, right? But when you are seeking payment, it needs to be from the party, especially if the attorneys are not going to pay you. If you have an engagement letter that you have drafted, that all parties have agreed to and signed, that indicate that you're holding the attorney liable for that payment, that's fine. I remember signing those all the time, right? As an attorney taking my clients through mediation. Whether that's enforceable or not, I don't know. The commission's not going to speak to what a judge is going to hold as enforceable or not. It is belief after many discussions, because this has gone around the commission numerous times. So we're aware of the problem. But the discussions have landed in the area of it's going to be up to the presiding judge whether or not the attorney can be held in privity of contract when the rules don't require that the attorneys pay the fee, but the parties pay the fee. So the solution would then be for the mediator to file a separate action against the attorneys in civil court for monies owed under a contract, which is going to take even more time and effort than filing the motion for contempt.
Can I ask you a question that I tried to put on the chat and sent only to Ray Owens for some reason? Ray just wrote me and said, hey, I'm the only one that saw this. I'm such a computer techno, but I've not had this problem, but I'm just curious. Has anybody ever had a situation where you got a bad check, a bounce check from a pro se party, or maybe even a lawyer? It's not happened to me, but that would just add further insult to injury. Nobody wants to take out a worthless check warrant or have to sue in small claim. I mean, in addition to filing with the court. So I'm just curious, has that ever happened? You all have done a lot more mediations than I have.
So Tara, that's another interesting question. If it's the lawyer or the client who gives you a bad check.
I've never heard of it happening.
I haven't either.
Everybody knock on wood real quick. I've never heard of it. I do know that we have in the works an advisory opinion regarding fees and what fees you can charge parties. So if you can pass along credit card processing fees, if you can't, how you can charge for, insufficient funds, et cetera. So hopefully we'll have that coming out in a few months after we get that processed and improved, but I've never heard of it.
What about the time for collecting the fee? Can you bill for that?
I think it's perfectly fair for you all to put anything you want in your service agreement. And I think it's perfectly fair under the rules, 7A, as long as the parties agree to sign into that contract with you, you can set term limits, you can set penalties, you can set anything, right? And under the statute, if you have to file a motion for contempt, the contempt that you can file for is not only the mediation fee that's due, but for expenses incurred in pursuing that motion. Again, good money after bad, pain in the butt factor, nobody wants to mess with it. I get it, right? But if you ever get to the point where you decide I'm done, I'm going to show big law firm A, who pays 8 months later, that I am tired of waiting, and you want to file that motion and take it through, you should be able to collect everything. And every time we have heard of a mediator actually filing a motion for contempt, it has been very favorable results for the mediator. Usually the judge is very hot that the parties even have to be there. And one of the beautiful things is if you're dealing with a party who's not paying the mediator, and you are looking at potentially filling out the form, which is what I encourage. I mean, hey, let's be real. I'm all about, teasing the parties to let them know, if you don't, then I will. Give them the ultimatum. So fill out the motion for contempt, copy everybody, say this is going to get filed tomorrow. If I don't receive payment within 24 hours, I'm done. Because if the attorney is still attorney of record, it's going to pull them into court. Theoretically, it should.
That's right, Tara. I mean, and I agree with your analysis about, the party's responsibility as opposed to the attorney's. But here's the other problem. Again, we don't have that relationship with the parties. Obviously, if it's pro se, we have their addresses, but just getting their addresses. I mean, you can't call the attorney up. I mean, now that we've got the portal, if the counties are online, we have an easier time getting that information. But that's a problem. And the other thing I just want to go back to is just, if the commission and the section, if we could talk about a way to streamline this for the mediators back before that form was in place, because now since the form's in place, the TCC will say, well, there's a form and you have to use that. Like, for example, Wake County, and in Wake County, for example, Judge Stevens, you would send the mediation coordinator, haven't been paid. These are the dates that I sent my invoice out, still haven't been paid. You copy the attorney with that. She put it into a form Judge Stevens signed, and he sent it. I tell you what, I got paid immediately. Now that was, we didn't have this form in place. I just called the trial court coordinator and said, what should we do? And she said, oh, send me a letter, and I've got this letter. And so, that was great, but now we just don't have that streamlined process. Again, we don't have the relationship with the parties. And so I think mediators' hands are tied, because I don't want to waste time going to a motion like Ann did, across the state to try to get paid. And so ultimately I just don't get paid. And I've got some that go out a year, and I just keep going. And eventually I normally get paid. But for example, I have 2 right now and they're attorneys, and I can just tell I'm not going to get paid.
Yeah. So Rick, let me just bring you in just quickly, because I think we may have spent most of our time on this topic, but with pro se parties, have you had these issues? I know you mediate a lot for pro se parties.
I regularly have these issues, and I've never filed a show cause motion. I routinely give them the paperwork to request, of a judge that they're declared indigent and they're not responsible for the fee. I don't think that often gets filed. Generally speaking, I see this, it's particular to us, but it's just the general part of being in business. How do you collect your money? And if you let somebody take a service or take that refrigerator out of your store without paying for it, you've got to figure out how to get your money. So that's part of it. We're trying to figure out ways to do it. I want to just throw something in here, if I may, and it's a little bit off from what you brought up, but I also do arbitration in district court, and the rules provide that there's a judgment filed, and it's a $100 fee. So we're not talking the same amounts of money as a mediation, but if it's not paid, there's a judgment automatically filed against the parties. And I'm wondering if that might be something to consider, if this is really widespread, that becomes part of the process. When you file your mediator report, once a mediation is done, if it's not paid in a certain amount of time, it becomes a judgment automatically. And that might solve this whole problem.
That would be pretty powerful.
Mm-hmm.
Yeah, and some of us who mediate in federal court, that would not happen. But yeah, that's an interesting solution, Tara. Maybe you could put that into the next, since it's already in the rules for arbitration. Perhaps that might be something else to think about.
Yeah, it's something that we can certainly run through committee. So I've got 2 issues right now to run through committee. And if there are more that I've missed, by all means, let me know. One of them is what Jackie brought up earlier regarding service, whether Rule 4 or Rule 5 pertains to the motion to compel. Motion for contempt. So I don't know. We can take it through legal and see what they say. I know that when I was in practice, I always served those by sheriff because I just didn't want to mess it up. But I don't know if it was because I was required to, or it's because I was just being too thorough. And honestly, it's been 6 years since I've been in private practice, so I don't remember. But we can look at that and see if we can change that to make it easier to serve. And then the second one is we can certainly look at judgments being filed if fees aren't paid against the parties. The concern that I have there, though, truly is that part of what we do is to make sure that mediation is available to the parties. And I cannot guarantee in any way, shape, or form that attorneys are communicating with the parties, right? So part of the disconnect is that mediators typically go to the attorneys and ask the attorneys for payment. I have no idea if the attorneys are talking to their clients regarding this. And because the parties are the ones that are responsible, I think that if we did implement something that allowed for judgment to automatically be placed on the parties for non-payment, that there would have to be some type of reasonable communication required with the parties directly before that process took place.
And therefore, we need to have their contact information. And that's, you know, when attorneys hire us, we don't have that.
So
And I'll tell you all real quick, because I know we've got a lot of topics, is that we're still working with Odyssey and trying to figure out how our forms are going to merge into that system. And we are on a heck of a learning curve. And I'm just going to leave it at that. But if you all have ideas, suggestions, recommendations, please let us know, because we are constantly looking at how the way we operate actually fits into eCourts and how reasonable it is for mediators to use and be able to gain access to that information.
So we have limited time. So right now we have about 20 minutes left in what we had allocated for this discussion. And we had a number of topics which had to deal with dispelling mediator myths. And I see Roy has raised one about the drafting of agreements, kind of what the current thinking is on that, where we could take another couple of hours to discuss. But the second one I have, and then maybe we do kind of go to Roy's topic of drafting, you know, but the second one, and I wouldn't even ask this question, but I still hear people say it all the time, is you know, people are saying mediators have to mediate, the mediation has to be conducted in good faith. The parties have to mediate in good faith. That's still something that is said over all these years. So Frank, you want to jump in on that? Because I know you're at the beginning of the rules.
Yeah, the group that went to Florida in 1990, whenever it was, I've got the date, but anyway, it's in the book. But the group that went to Florida interviewed a bunch of people or talked to a bunch of lawyers and judges, and they said, we have this must mediate in good faith. It sounds nice. It sounds like a good rule. You know, everybody really ought to be in good faith here, therefore we're going to require it. But the problem was that if the case didn't settle, almost automatically one side or both sides would say they didn't mediate in good faith. And so instead of one lawsuit, if it doesn't settle, you have at least 2 lawsuits, the underlying accident and then the charge of not negotiating in good faith. And so the decision of that original committee was, we ain't going down that road. We are not multiplying litigation here. And so there's never been a requirement that they mediate in good faith. The requirement is that they show up and that they pay the fee and that they record in writing any agreement. And that is it. I've had a mediation where a city in the state of North Carolina showed up at the mediation, and the city attorney said, I'm here. Thank you, Mr. Laney. I have nothing to say. And I talked to him for a few minutes, partly in public and partly in the whole group and partly in private. and I understood why the city had formed a policy, the way they want their city to operate. And if a federal court says you are violating the Constitution, then they will change it. But until that occurs, they formed their policy and there's nothing to talk about. And the policy was basically the lights are either on or they're off. There was no in between. Either the lights are on or the lights are off. And so he said, thank you for your time, but we have nothing to say. And once I understood that position, I said, okay. And so I'm sure the other side thought, oh, they're not here to negotiate in good faith. Okay, but that's not a requirement in North Carolina. I'm sorry, but that's it.
Oh, good. Thanks, Frank, for that background. And Trish, I know people say that in your cases, just like they do in mine. Do you respond to them, Trish, when they say it, or do you just ignore it?
I just ignore it.
That's what I do too. I used to address it, but I just ignore it and I just go, no.
Yeah,
Anybody else address it when somebody says it?
And what I've tried to do is to explain why you're here. You didn't ask to be here. You want a jury trial. You got every right to it, but a judge ordered you to be here. You're here. You've taken time off work. And if you want to fold your arms, tell the other side to go jump in the lake, that's your right. That's your privilege. But as long as you're here, as long as you blocked off the day, as long as you're missing work, let me encourage you all to have an open mind and encourage you to talk about the case. And I've never had any blowback on that.
And Ken, I see you turned.
Yeah, it's usually stated by the party who isn't satisfied with the other party's offers. That's what I usually hear. They're not here in good faith. And I will normally address it, but I'll do it in a very kind of gentle, almost, I won't say humorous manner, but a very light manner of saying, well, you know, y'all, there's technically no requirement for that. But there is a requirement to mediate. And just remember, there's no requirement to pay a dime. You know, there's no requirement to settle. And everybody just kind of ponders that for a second and moves on. So just don't let it be a problem.
So, okay, well, anybody want to take the helm of talking about Roy's question on what the current status of mediators drafting? Tara.
I will.
Yay.
Okay, so to let you all know, we are still working with the State Bar regarding a formal opinion that we requested. When I say we, I mean the commission requested, regarding a mediator's potential liability for bad terms being included in the contract. Okay, so I don't have an answer on that yet, but we've been working with them. They've been great. Hopefully we'll have something in the next couple of months that will give some guidance as to what happens if one of the parties says to the mediator, hey, can we contract for, you know, human trafficking, because we think that would be great. And then the mediator standing there going, oh my God, right? So hopefully we'll have some clarification on that. For now, the commission has encouraged me to continue to tell mediators, never draft, okay? Because the State Bar sees drafting as legal advice, which then conflicts with our standards, okay? If you are working with parties where every single party, including the missing defendants or people who have been excused from the mediation, are represented by counsel, mediators may act as a scrivener as long as they do not include any boilerplate language or provide any recommendations on how terms should be filled out, etc. But I am still old school, and I'm going to encourage everyone to just have the attorneys draft the agreement. I know that this doesn't always play well into other organizations such as Industrial Commission. I think OAH mediations are kind of along those same lines, but when it comes to court-ordered mediations through Superior Court or Family Financial, best practice is to have the attorneys write the agreement.
Okay. And
one of the problems with the State Bar's position, as I understand it at this point in time, is that yes, you are free to draft when everybody's represented by an attorney. You can write anything you want as a scrivener, but the problem is you are personally responsible if you include a clause in that agreement that the state bar doesn't like. Well, what does the state bar not like? I have no idea. So if you want to run that risk of the state bar coming back after the fact and say, oh, by the way, you should not have included that clause, it's improper in some way, then go for it. But that was the problem that was one of the problems with that the mediator that we've all been talking about for 2 years had, that they included something the lawyers told them to, and then the state bar came back a year or 2 years later and said, oh, by the way, that was unethical, you can't do that, and hauled her through, keel hauled her for a couple of years until she said, I'm sorry. Although it seems that they have now dropped the case. It's a little unclear because their process is not completely transparent, but they apparently have decided that keel hauling her some more was not worth the trouble, so they've dropped it. But if you want keel hauling for 2 years, go ahead and write the agreement and run the risk that maybe you'll include a clause that, by the way, after the fact, the state bar will say we didn't like.
So Ray,
I'm sorry,
go
Ann.
ahead. No, go ahead, Jackie, if you've got something to say.
I mediate industrial commission cases, and I understand what you're saying, Tara. Their form is pretty much just check the box. Sometimes we put some extra provisions in there that everyone requires. And the attorneys will tell you to do that. In Superior Court, if I have a case that's different, unusual, or whatever, I 100% ask one of the attorneys to draft it and just tell them about what's going on with the state bar. But, the Superior Court form in a car wreck case, for example, that's what that Superior Court form seems to have been made for. It's just checking the boxes, defendant shall pay, within X days, that sort of thing. And I will say that I'll check those boxes and I have everybody look. Obviously this is when everyone's represented by counsel. If there are extra provisions that get in there, again, I just say, look, this is what's going on with the state bar. I need to, but attorneys cannot figure out how to check the boxes or how to put, so you've got an extra 30, 45 minutes, just, basically you're doing share screen, you're going, okay, check that box. It's, I think that it is a service we provide. But again, if you're getting into, and I've had a couple where I'm going, I don't know. And so I definitely, now with what's going on, won't draft if it gets into, something more complicated. Although, it pains me because I do feel like that's a service we provided, at some point.
So Ray, do you get your parties to bring a draft agreement to the mediation if possible? Is that something you've been doing?
No, typically Zoom, I will send out the MOA as part of the invite, and then I haven't heard that the state bar frowns upon me bringing a blank form, so I'll bring that. But I'm like Tara, I'm old school. I don't have any interest in key haul. I've never even heard that verb before, Frank. I think you made that verb up, but I immediately turn to the lawyers and say, and I like Jackie, I give them some background. Here's why this is about, and I just don't prepare the form. And my experience is only male attorneys can't fill out the form. But I regret it, because usually if I think they're there, you can fill that out and you say 15 minutes, right? But it's been a year and a half and I haven't touched one other than here it is. I made data form. I hope that's okay, but I don't do any more than that.
Well, and so let's talk about this issue that ties in with that. Attorneys, I think, still think that they can sign on behalf of their missing client, or if the client has left, or if we want to talk about what's required now, if an attorney wants to sign on behalf of the client. Tara?
So those rules are currently pending, and they're in front of the Supreme Court. We're modifying them a little bit to be more consistent with the advisory opinion we issued. Basically, if a party is not necessary or not needed or not able to attend a mediation, and all parties agree, including the mediator, that that party does not need to attend, And that party who is not attending may provide written confirmation that they have assigned someone or designee to sign any agreements on their behalf. That written verification can be in a text, it can be in an email, but the mediator needs to see it, indicating, you know, that they understand that the party is giving authority to somebody else, and then that person with authority may sign on their behalf.
And I've had that pop up recently, so I thought that was important to mention.
The tough balance, excuse me, the tough
go ahead.
balance is kind of this, as somebody said, maybe Charles, goal of educating the bar about what they don't know about the process, and some sense that I'm practicing law. That is, you know, you need to get your client to send you an email, you need to get a text, you need to get authority. I get a little bit nervous about being too advisory about those issues, but you do want each lawyer to be educated about what's, at least in 2024, what's appropriate, what may not work. And the state bar is, the shadow is out there. And so it's kind of tough to educate if, on the other hand, you're now interfering with the process and telling one lawyer, well, here's how to make it enforceable. I don't know. It's a little bit of a challenge, I think.
It's an extreme challenge. And I feel like most of the time what we do is try to avoid landmines and to draw, you know, a diagram on the sidewalk of hop here, hop over there, jump 2 feet. The best thing I can tell you about not providing legal advice is to point to the rules. You know, if you've got a party who's asking you as the mediator, hey, I've got a client that doesn't want to attend, what do I do about this? Cite the rules, right? Or send them to me, I'll tell them the rules, right? But hopefully that will help, and then they can draw their own conclusion as to whether or not their party needs to be in attendance and whether or not their party can give signing authority to someone else.
So Tara, I know we have the mediation CME coming up that the DRC is sponsoring, and this group is going to be active in that. Is that open to attorneys who aren't certified mediators? So could you just mention
Yes.
that, and maybe that's something else we could try to encourage?
Yes. So I asked Anne if I could give a plug today, because the DRC is hosting its annual Conflict Resolution Day celebration in October. It's on October 17th, on Thursday. Unfortunately, because our building is going to be under construction, we are doing everything remote. So we're keeping it simple this year. And the people that you see on the screen, it's actually the exact people I have tagged and begged to appear on this screen in October. So we are doing mediators of the roundtable. You all have asked me multiple times if these little productions can be for CME credit. So we're trying to give the public what they want. We're going to have 2 hours of open discussion, covering anything and everything. I want, if you all have questions and you want to send them my way, I will make sure to include them or incorporate them as best as I can. But it is open to anyone and everyone. It will be, if you want credit for CLE or CME, then you need to register with Maureen or Mary by sending her an email to let her know. But the links will be posted the morning of. We're trying not to post the links to the production immediately, because we want to try to register everyone. So anybody that sends us an email saying that they want to take the course, we will keep a list and send out that link when it goes live right before it starts. But if you want to share the invitation with law firms, with clients that you work with on a regular basis, by all means, please do.
Okay. Yes. So that might be a way to attract litigators, but I don't know. I mean, that's who we need to educate. And Denise, as we're thinking forward through the year, perhaps that's something that the section could emphasize. There are so many things that litigators don't know. And I think, Ray, you said before that they think they know. And so getting the litigators to focus on what they're not aware of is very hard for us as mediators to do. But we, I guess, have to see if we can't take the helm on that and be helpful.
And can I backtrack 1 second?
Sure.
Talking about a party giving the attorney authority to sign the settlement form, as the Superior Court judge who got reversed by the court on that case. Let me tell you, one of the problems was that the client said, I never gave him authority. I never gave authority. And the attorney was saying, yes, he did. Yes, he did. Well, I foolishly, and they even got the mediator to come to court to testify about it. And of course, I never should have done that because that was breaching all kinds of confidentiality. So if you get into a skunk contest with, between the client and the lawyer, if there's authority to sign, even if the rule is changed, that's not going to eliminate that. That's just a nasty problem. And so I'm even if the rule has changed, I'm going to be very wary about ever letting an attorney sign for anybody unless it's under some extreme circumstance, somebody's on their deathbed or something.
Well, and Judge Caldwell, to reiterate that in order for the party to skip the mediation, the mediator has to approve it. So the mediator does have that overlying authority and control over making sure that all parties are in attendance.
But in that case, the mediator testified about that, and as I recall, the court said, "Look, he's not even supposed to be talking about this." They really slapped my hand pretty bad, and I guess I deserved it.
Well, that's how we all learn, is through these challenging experiences. Well, we've been at it for an hour, folks. Thank you. I hope the folks who are listening got some helpful tips, a lot of time, a lot of experience here on the screen. Very much appreciate it. Let us know. Our plan will be to host another one perhaps sometime in November or December if there's interest. And thank you, Kyle. Thanks for everything as always. And we'll see you in November or December. Thank you, folks.
Thanks, Ann. Bye,
Thank you.
everyone.
Thanks, everybody.
Bye. Bye.
Great